This is Dr. David Shine, and welcome to Business Law 101. Now, one of the types of damages that is most commonly excluded from recovery in contracts are what are called consequential damages. And consequential damages are what happens after compensatory damages. In other words, if somebody breaches a contract and you not only have lost labor and different things, but you also lost profits. Lost profits are usually considered consequential and not direct compensatory damages. So many contracts spell out that if the contract doesn't work out, that you still can't recover consequential damages. Now, we again talked about punitive damages in the torts chapters in Module 2, and they're also called exemplary damages to make an example out of a defendant. And so the punitive damages are, again, it looks like the word punishment, the English word punishment, and it's basically to reward someone, punish the other side.
So, Professor, what is the difference between consequential and punitive? Because they sound the same.
Well, consequential has to be based on some basis. So in other words, if you have a contract and you, in my hypothetical with the machine shop, you have you have blanks that are each $400, that's compensatory damages. If on top of that, if you're going to machine each one of those and make a profit of $50, then for each one of those, your consequential damages was $50 per unit. So that's profit. That's usually separate from the compensatory damages. Punitive damages would be to say, well, you guys deliberately manipulated this to cause a big loss for that machine shop. So in addition to giving you the $400 that you were out of pocket, plus the $50 lost profit, we're going to give you another $500 per unit to show the big company that they can't beat up on the little company. So that's punitive damages. Now, again, in many contracts, not only consequential damages are excluded, but punitive damages are excluded also. Now, liquidated damages are a special tool that's built into some contracts. And the way this looks is you have a deal, and this often happens with non-compete agreements because it's hard to estimate damages in a non-compete agreement. So you might say, you're going to work for us, and if you leave, you can't work for our competitors for a year. And if you go to work for our competitor for a year, we agree that the least damage you're going to cause us is what you would have made in 2 months. So if you were making $10,000 a month, then we agree that the least our damages will be is $20,000. That's a liquidated damages clause. And again, it's somewhat common in non-compete agreements. Now, I will also tell you editorially, which they don't tell you on this slide, judges do not like liquidated damages clauses. They like people to come forward and prove up real damages. So many judges will not enforce a liquidated damages clause. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.